NDC amanyɔkuo no atwerɛ krataa tententen de kwa akɔma the Chief Justice of Ghana. Na obi bebisa sɛ ɛdɛbɛ asɛm ɛna aba. Yɛte krom ha ɛna Parliament House of Ghana ɛpasi anti trumu bill no. Enti na ne aka ne sɛ President Akufo Addo bɛsan na ndi abɛyɛ mmara ɛwɔ Ghana krom ha se. Na President Akufo Addo ti sɛ Parliament apasi no ɛna ɔtwerɛ krataa de kɔma Parliament sɛ mo mfa saa bill no nsi na aboboa no na nkrɔfoɔ bi di asɛm na ayɛ den akɔ court. Ɛsɛ sɛ yɛtwɛn Supreme Court ruling. Enti asɛm na President Akufo Addo kan no Parliament House the response by ɛno kra nam so ɛma yewra Nelson Dafiamokɔ no nso di asɛm bi ɛkɔ court sɛ ɔmo nso ɔmo pɛ kwan sɛ na ɛbɛyɛ a ɛyɛ yɛ friends and ministers na ya nominate ɔmo no Parliament ya approve ɔmo till sɛ Supreme Court asɛm ruling we bɛba me kyerɛ trumu ruling ne bɛba abɔnten na asɛm na nkrɔfoɔ edi kɔ court ayɛ sɛ yɛ ruling in term na ehu baabi ɛbɛda no yɛnya ntachi saa case no ɛna Nelson Dafiamokɔ mo asɛm ɔmo de kɔɔyɛ no ɛna yɛsɛ yɛ ruling yɛ no ansa ya jump ɛna yɛ bɛ ruling saa case we. Don't get me wrong, even Ile asɛm ɔmo de kɔɔyɛ friends and court somewhere 2 years ago no yɛnya ntachi saa case na da so wɔ Supreme Court hɔ no enso Ile bi yɛgye wɔ krom ha. Nti NDC amanyɔkuo kyerɛ sɛ yɛayɛ din akyɛ this time around there we have to talk and ɔmo release krataa. This is the letter yankenkan press statement 27th March 2024 for immediate release. NDC reacts to palpable judicial bias in the scheduling of political cases in the Supreme Court of Ghana. Was it the National Democratic Congress has become aware of the decision by the Chief Justice of Ghana to list the case of Roxanne Nelson K. Dafiamokɔ, the Speaker of Parliament and the Attorney General, for hearing on Wednesday, 27th March 2024. The NDC is intrigued by the listing of the Dafiamokɔ case for hearing ahead of the case of Richard Delaskai, the Parliament of Ghana and the Attorney General. Enti has said one person which has said Nelson Dafiamokɔ asem no ena yesi ye di ne sesia enso asem an bezo mudini Richard Delaskai any friends saying Attorney General no asem. That's the your friends say case and say omudinu but prep on my dumpy and on my to America ko tam Dafiamokɔ asem no and omu kura mu dindin say eno na omu de ruling beba first. I say, it is interesting to note that Richard Delaskai filed his writ of summons in the Supreme Court challenging the constitutionality of the Sexual Rights and Family Values Bill 2024 on the 5th of March 2024. This was almost 2 clear weeks before Honorable Roxanne Dafiamokɔ filed his writ of summons on 18th March 2024 challenging the constitutionality of the latest ministerial nomination by the president. So if you listen to this case, the last guy any idea asem court say sa your friends and to move forward more right ni ade so yan rule asem no sa asem na da court President Akufo Addo say enye den yen no. That's the case at court President Akufo Addo say yen no. NDC say instead of Supreme Court ruling that case no Omar Jai and Dafiamokɔ asem onu di call 18th of March and now ya no e no omu so omu be di sa asem omu so omu dwun omu nti ase case esese omu di na animani ya na ye nyina ye de ye ti ase se o trumu asem no mu rule ama case na akoda se na president be sign wa sign bill no mu rule e no na Dafiamokɔ asem o di call 18th March ya o si rule ena your friends and the last guy assembled to call 5th March no also rule and no and now this force of Mundias. Now look at this place. Was it given the recent political deadlock that deadlock that these two legal suits have created between the executive arm and the legislature arm of government, one will have expected that the date of filing of the cases will have informed the timing of their hearing by the apex court. Yet, for some strange reasons, the case of Honorable Roxanne Dafiamako, which was last in time to be filed, has been hurriedly listed for hearing tomorrow, while that of Richard the last guy, which predated the Dafiamako case by 2 weeks, has not been listed for hearing at all. In the case now, Dafiamako di ko ye na say ye bia mu na obia hu ne tuam na ye di no omunya hu fi Dafiamako case ye call 18th ya no na omewuri 18th, and then date year saying, and then 27th, 18th, 19th, 20th, 21st, 22nd, 24th, 25th, 27th. Into 1 week ni ena Dafiamako di ko ye see ye di this here. This is in spite of the fact that no application for abridgment of time has been filed by any of the parties in the Dafiamako case. It is quite apparent that this is a ploy by the Chief Justice to fast-track the determination of the suit filed by Honorable Roxanne Dafiamako, while the determination of the Richard the last guy suit is deliberately and unduly delayed to enable the president shelve the crucial sexual rights and family values bill that has been passed by parliament. In the Omutre say, Adé with Chief Justice Ashadana Oye we say nebeya President Akufo Addo sign as say or sign on signs are to move bill. One say even more bizarre is the fact that the case filed by some NDC members of parliament challenging the constitutionality of the passage of the electronic transfer levy bill as far back as 2022 has not been listed for hearing by the Supreme Court till date. And almost signed it twice to say, levy assembly by no electronic levy assembly by minority MPs be the court Supreme Court to say, sir. Tuano de any kwanse Ghana for Ntria, any kwanse Ghana for Betriano, assembly da court or Supreme Court in be your own can she Supreme Court I since 2022. Bepimende, Yavas almost 2 years in the Supreme Court and touchy sakis no. In Sunansia, they see a touchy. Everything shows. Tiwe. Or say, the arbitrary exercise of administrative discretion by the Chief Justice, particularly in the scheduling of cases in the Supreme Court, goes to fortify the high perception of bias on the part of the judiciary. Such judiciary manipulations go to confirm the growing public perception that the current Chief Justice is a pliant accomplice and abettor of misrule of the despotic Akufo Addo /Bawumia/NPP government. While the Constitution of Ghana vests discretionary powers in the Chief Justice in the discharge of her administrative duties over the judiciary, it is important that such discretionary powers are not exercised arbitrarily, capriciously and whimsically. Judicial independence must mean exactly that. At no point should the judiciary act in a manner that lends itself to the grounded belief that it is willing to aid an overbearing executive in standoff with the legislature. Chief Justice this Supreme Court and Jabi Bia Magana for Mekasa Ampa, Adunya ye been say. Bibi omujina binding side no ababa ye no kure because me omuye de edamufwa edamu clear obi ahu. Was it the Chief Justice must appreciate the justice emanates from the people and the judiciary exists to serve the overall interest of the state and not the interest of any particular political party or government. As such, fairness and balance must at all times shine through their work. The listing of this particular case filed much later than this than the Sky case, was it the listing of this particular case filed much later than the Sky case does not reflect these vital prerequisites. We have come too far in our constitutional journey to allow such glaring manipulation to pass without protest. Such behavior as constantly exhibited by the Chief Justice against entities opposed to the NPP has gone on for too long. This does not only undermine public confidence in the judiciary, but it also makes mockery of our democratic arrangements. There can be earthly justification for listing the Dafiamako case ahead of the Richard Sky case, and we demand an immediate rectification of this travesty. As the political tradition embed the fourth republication, democracy, and constitution, we are extremely concerned about this biased handling of cases by the Chief Justice, which appears to be fueling the ever festering perception of judicial bias in the country. These acts of judicial arbitrariness titled in favor of the ruling Akufo Addo /Bawumia/NPP government do not engender public confidence and trust in our justice delivery system, and this should every well-meaning Ghanaian legitimate cause for concern. Hey. Signed Fifi Via Liquidity, General Secretary, National Democratic Congress, NDC. Hey, bro, for me. NDC for bro for pani. Bro, for even tida. Chai! Bro, for even tida. Bro, for pani. NDC. Assembly, I don't know. You're a Fifi Liquidity, just say. A dear Supreme Court here and dear, and as a Chief Justice here, the more clear say the Omu and dear, or just say they do things in favor of the government too much. Was it Ghana for whites? I've been that, but no Muya Bema and Pat or Mano Munjin denied Jadi. That's the case. O my eye, he live the assembly the ruling yet. I said that Fiamako case or they call 1 week ago, the day 27. Today is exactly a week. I say yearly. Hey! Now one you beat baby say both parties are the same. The previous government time, did you see some? This government to me something clear. I'm going to say yes, clear or more fine. And this is what is happening in our judiciary. One pass him a comment. Me didn't edit